Unfortunately, the Screen-O-Matic software does not work on my computer, and my voice is a little hoarse from staying up on lately on this, but we're going to present it today like this, and so hopefully we can get a little bit of knowledge and background into myself. My name is Yusuf K, first of all, and I'm a 27-year-old personal trainer from Los Angeles, California, and I've chosen to work on a facility background of a strength and conditioning facility. The kinesiology-related field is the one that I've chosen, and becoming college strength and conditioning coach is what my ultimate goal is, so I thought that would be extremely applicable. So the first issue in the facility background, such as a strength and conditioning facility, was gross negligence. This occurred in the case of Tarlia versus Crabtree, a high school football player who collapsed and died at a nearby hospital after 1.5-mile conditioning run. The defendant exhibited a high degree of care and professionalism in their role as a coach, and the coach took numerous safety precautions, including providing water, encouraging rest breaks, and even offering the option to abstain from running. Providing adequate care to the athlete is why they weren't held responsible. So in this case, the high school football player was treated with care, and so gross negligence was not a result of this case. And so we'll want to go on to causative negligence, which was the next case. The plaintiff, Donna DeMara, was struck by a golf ball during a physical education class at her private college. Negligence was found by the court based on the breach of duty of supervision and instruction that the school owed to the student. So in this case, the student was struck by the golf ball, and that caused causative negligence because she was hurt as a result of the cause of someone who worked for the university. Now, in the other case, gross negligence wasn't found because good care was taken. So gross negligence is an extreme lack of care, and causative negligence is a little lesser degree. But in the future, receiving expert advice from professionals who implement accepted practices and standards in a particular sport is advisable. So not having an assistant or any type of interns that are teaching the kids or the students the actual sport will help prevent this in the future. And in terms of the gross negligence from the previous slide, you always want to make sure, like I said, that in any workout condition there is water and there is active rest breaks, and you're allowed to stop if you do feel sick. The next case is Klein Connect versus Gettysburg College in 1993. So the point here is to have an emergency action plan. And so in this facility, there was a playing lacrosse, and Mr. Klein Connect became unresponsive. The school had no plan in the event of an emergency. So this is key, because without a plan, a specific course of action, should be implemented and written down and practiced regularly, of course, so that in case of emergency, it can be executed. So the next slide goes into issues in risk management. And so the case of Day versus Ochita Parish School Board in 2002, there was a risk identification evaluation that needed to occur. So Morgan Day was an athlete on the high school football team and injured his back during a weight training class one day. An orthopedic surgeon wrote Megan a medical excuse stating no football for 1 week and no weightlifting, squats, or power cleans. Diagnosis: a lumbar strain and injured L5 disc. One day after the note was posted in the strength and conditioning facility, Morgan was told to lift weights by an assistant coach when he injured his back further and was excused from all field football activities indefinitely. So this was a case where risk identification and evaluation was not observed properly. And anytime an athlete has an injury, they are especially prone to being at risk for another injury. So the coaches have to be especially careful in tending to those athletes. The coach who insisted on him performing a dumbbell power clean push press, him insisting that it wouldn't hurt Day's back, was in clear violation, like I said, of his obligation as an instructor to adequately assess risk. In order to prevent a situation like this from occurring, the supervising adult should either employ retention, treatment, transfer, or avoidance. So a risk management strategy includes all or one of these. In this case, avoidance of the actual exercise would be the most necessary in order to reduce injury. The next issue came up in risk management concerning instruction and supervision. supervision. So in the same case, it's also vital and integral that proper instruction and supervision occurs. So it's not enough to just evaluate the risk. You actually have to know what you're doing in telling what the athletes how to perform the lifts and the techniques involved. So in order to prevent an injury such as this from happening, instructional guidelines should be followed when it comes to injured players. Establishing a protocol that explicitly lists injured or ill participants should not be allowed to participate without appropriate medical clearance is necessary. Any recommendations to the contrary should be ignored by the athlete and reported to the head trainer, head coach, or athletic director. This is extremely important to follow medical leave and medical excuses because they are there for a reason to help athletes recover and shouldn't be pushed further. So instruction and supervision includes injury prevention, not just teaching techniques. The third risk management strategy that must be employed is having established emergency communication rules. So in the case of Kleinpeck versus Gettysburg College, Kleinpeck was collapsed while playing lacrosse, and the nearest phone was 250 yards away in the training room. And so in the future, it's definitely necessary that a phone is within sight of practice and game fields. In 2017, this shouldn't be a problem, but you never shouldn't take that for granted. So the lawsuit against Gettysburg College showed that it breached its duty to fail to provide prompt and adequate medical services. This had to do with not having the phone available. So the next case is going to come up, Coleman versus Western Michigan University, and this is why I'm going to start to talk about employment laws. So student athletes are not employees. In this case, the plaintiff was injured in practice while playing football for Western Michigan University, and Coleman sued the school claiming to be an employee of the school. But the relationship had to meet 4 criteria: the employer's right to control the activities of the employee, the employer also has the right to fire or discipline the employee, the payment of wages must occur, and whether the task performed is an integral part of the business are also conditions of an employment relationship. So in this situation, not all of these situations were fulfilled by Mr. Coleman, and therefore the court constituted Coleman's scholarship as wages, which included room and board, books, and tuition. In order to manage situations like this, an athlete who signs a letter of intent must thoroughly understand the details of the contract. If an athlete refuses to participate or is unfortunately injured, they are not owed the same benefits as a university employee. And college coaches who are largely responsible for keeping their athletes informed on the rules and regulations regarding participation in sport. So a college athlete should definitely know what the rules are in terms of his availability to practice and playing games, and whether that has to do with him being employed as a university employee is a separate issue. The next case comes up versus and it's Moore versus Notre Dame, 1998, and it's a classic case of age discrimination because the plaintiff, Joseph Moore, an assistant football coach, filed a claim against the University of Notre Dame, alleging age discrimination, retaliation, and defamation. The court found the University of Notre Dame guilty in violating the Age Discrimination Employment Act, the ADEA, and in terminating Moore. So they kind of had a tumultuous relationship between Moore and the staff there, and because he was an older employee, they terminated him, but they had no right to do that. When a violation of the ADA occurs, the court is allowed to offer as reinstatement, back pay, injunctive relief, declaratory judgment, and attorney fees. So in this situation, I believe that he was awarded back pay, and it's really important that supervising managers are aware of all the rules under the ADA, because older coaches often have a harder time finding work and are more vulnerable to negative aspects of being unemployed. Third case in employment laws is going to deal with sex discrimination. So Marianne Stanley was hired as the head coach of the women's basketball team for USC in 1999 when this case occurred, and she had a lot of success. And after her initial contract expired, Stanley requested a new salary equal to the USC men's coach, George Raveling. Stanley filed a lawsuit under sex discrimination and retaliatory charges. But unfortunately, Stanley had conspicuously failed, moreover, to present any meaningful evidence in support of her claim that she and Raveling had comparable levels of experience. So basically, in this case, because Raveling had a higher tenure and was a coach for longer, although they had similar success in terms of winning record. The case was not ruled in her favor. So athletic directors should make sure contracts stipulate specifically that certain positions receive salary based on tenure and previous experience. It is up to the employee to accept the experience as a qualification for a higher salary, and maintaining good faith and understanding the parameters under which a contract is being negotiated will help manage disputes such as this in the future. So now we're going to go on to application and faith integration. And what I've learned so far that can help me as a potential strength and conditioning coach is the concept of foreseeability. A lot of that occurred in some of the case studies and things that we've studied, in that you, as a coach, has the obligation to kind of foresee and learn and become wise and grow in what he's learned. And if he doesn't execute some elements of foreseeability, or seeing things such as back injuries or potential equipment violations that could be stopped, and if he lets that continue, then you basically could be held liable for negligence and things like that. So reducing risk by foreseeability was a really important thing that I learned. In addition to having an emergency action plan, communication devices, and understanding the obligations of athletes as it pertains to the school, and understanding that employment is fragile, and so laws and regulations must be followed. The next part comes onto the faith integration. So I found one person, Peter 4:10, as each one has received a special gift, employ it in serving one another as God's stewards of the manifest of God, as good stewards of the manifest of God. So a good manager, athletic director can use his or her vast understanding of kinesiology to get the most out of their athletes in hopes of glorifying God. This verse may help a manager establish precedent for employing someone with a physical disability but a mental gift. Next comes from Timothy 6:10. For the love of money is a root of all kinds of evil. Some people eager for money have wandered from the faith and pierced themselves with many griefs. Managers shall hire, so to me this meant managers shall hire employees who are passionate about their field and not simply for the money. And this reference can help establish precedent for allocating salaries, so that, a person can maybe, an athletic director can maybe start lower, maybe more work incentive based, because if you start high with higher salaries, you might attract people who have higher ambitions, and then you might not know what their true desires are. So Philippians 2:4, each of you should look not only to your own interests, but also to the interests of others. So one's own interest should always be put secondary to the obligations of the program that a faithful athletic director has. So if a director or manager is faithful to their program, then they won't put their own interests and be selfish. And if they have side things, they'll put those to the side and make sure the program is first. This verse may help the athletic director who's on the fence about potentially hiring a female coach and look through his or her assistants. So, you can also look at that as helping you, not you can look to the interests of others in terms of what are the interests of others under you, and how can you help serve them to succeed. So the last part of the faith integration I want to talk about is using God's word to guide a career. And it can be beneficial if it's done in a way to not interfere with the sentiments of others who may disagree. So kind of like you want to always maintain your faith and talk about it with people you're comfortable with, but the term kind of preaching on some people can get difficult to deal with, and you may not always be in a setting where religious beliefs agree, so you can't just put your religious beliefs on people. Church and state is sometimes separated, so you have to observe that, even though you can certainly be a faithful person as you continue your career. This has to be done potentially in a more clandestine manner. I don't believe there's really anything illegal that I would say is on my moral side, but I do believe drugs such as diet pills, opioids, high amounts of caffeine that athletes might potentially take, they may be legal, but they aren't really ethical because they could cause problems and health problems. So those were kind of the points I made, and I wanted to thank you so much for listening to this presentation. I had a great time. Here's some of my references, and thank you so much.